He had a valid PAL, his firearm was registered, he had followed every storage rule, every transport rule, every regulation the government had ever put in front of him. And when those lights came on behind his car on a quiet stretch of highway, he was not worried. He had nothing to be worried about. He was legal, he was compliant, he had done nothing wrong. 40 minutes later, his firearm was sitting in an evidence bag in the back of a cruiser. Not because he broke a law, because nobody had ever told him the 3 words that would have changed everything. And that is the story playing out on roads across this country right now, because most Canadian gun owners do not actually understand where their rights begin and where they end the moment an officer reaches their window. Here's what you need to understand before we go any further. Section 8 of the Canadian Charter of Rights and Freedoms gives every person in this country the right to be secure against unreasonable search and seizure. That is not a suggestion. That is constitutional law, confirmed again and again by the Supreme Court of Canada, going all the way back to the landmark Hunter versus Southam decision, which established that warrantless searches are presumed unreasonable unless the police can show reasonable and probable grounds. Not a hunch, not a feeling, specific, articulable facts. And here's the principle that Canadian courts have been unanimous on, case after case, for decades. The mere presence of a legally possessed firearm does not by itself create those grounds. Your PAL is valid. Your firearm is registered. You have done everything the law requires of you. That is not suspicious. That is not evidence of a crime. That is a person exercising a lawful privilege exactly the way the government designed it to be exercised. Police cannot treat your legal compliance as if it were probable cause walking around on 2 legs. That principle is exactly what is being eroded every single day on the side of Canadian roads, and most gun owners have no idea it is happening to them until it is too late. Here's how it actually unfolds. An officer pulls you over for something minor, a rolling stop, a tail light, nothing serious. He approaches your window. He is calm, professional, doing his job, and somewhere in that conversation he learns there is a firearm in your vehicle. Maybe you disclose it. Maybe he sees the case. The moment that happens, the entire interaction shifts. You are no longer in a routine traffic stop. You are standing at the exact line where your charter rights either protect you completely or get signed away in 30 seconds without you even realizing it. Most people in that moment do exactly the wrong thing. They start talking. They explain. They say things like, "It's registered. I have my PAL. I've had this gun for years. There's nothing else in the car. Go ahead and look if you want." That last sentence, said by someone trying to prove they have nothing to hide, is the sentence that ends the conversation about rights entirely. Because the moment you say go ahead and look, you have consented. You have voluntarily given up the very protection that Section 8 of the Charter was built to guarantee you. And once you have done that, no court, no lawyer, and no ruling can undo it. Consent overrides everything. So here's what protects you instead. When an officer asks if he can search your vehicle, and he may ask, you say 3 words: "I do not consent." Calm, clear, once. Not an argument, not a lecture about the charter, just those words, and then silence. Those 3 words are the entire wall between your rights and his request. Without your consent and without specific articulable grounds beyond the gun itself, that search is not lawful. You have not been rude, you have not been difficult, you have simply declined to hand over the one thing that would have made an otherwise unlawful search legal. But here is where this protection completely falls apart for a lot of legal, responsible gun owners, and it has nothing to do with the officer's intentions. It has to do with how the firearm is being carried. Non-restricted firearms must be unloaded and kept out of plain view during transport. Restricted firearms, most handguns, must be unloaded, fitted with a secure locking device, and placed inside a locked container. And the trip itself must be covered by a valid authorization to transport. If an officer looks into your vehicle and sees a firearm sitting in clear violation of those storage rules, the conversation about consent never even gets started. He does not need your permission to investigate something he can already see as a criminal offense under Section 86 of the Criminal Code. The gun is legal. The way it is being carried is not. And that distinction is what thousands of otherwise responsible gun owners lose every single year, without ever raising their voice or breaking a single other law. There's also the combination factor, and this is the part almost nobody talks about. Your 3 words protect you against a search based on the firearm alone. They do not protect you if there are other factors at play: a nervous passenger, the smell of something illegal, inconsistent answers about where you're going. An officer is not going to say he searched because of the gun. He is going to say the gun combined with everything else he observed, created the grounds he needed. He may be completely right. Courts have never said police must ignore genuine evidence of criminal activity. What courts have consistently and unanimously said is that the firearm by itself, in isolation, with nothing else present, cannot be the entire justification. If the search happens anyway, after you have clearly refused, do not resist physically. State once, clearly, loud enough for any camera nearby to capture it, "I do not consent to this search," and then stop. Let the officer's actions become the entire story. An unlawful search challenged later with a clean record of your refusal is a case a lawyer can win. A confrontation on the shoulder of a highway is not. The moment the stop ends, before you drive another kilometer, pull over and write everything down. The time, the location, the officer's name and badge number, the exact words exchanged, whether you consented or refused, what was said, what was found, what was taken. Memory fades fast, and it fades selectively. What you write down in the next 5 minutes is what your lawyer will use in the next 5 months. Your rights as a Canadian gun owner are real. The Charter protects you. Decades of consistent, unanimous case law protects you, but none of it activates automatically. It only works if your storage is clean, your documentation is current, and you know exactly what to say the moment that officer reaches your window. 3 words. Say it calmly, say it once, and nothing else.